Ramdeyal,
Good afternoon, Chief Justice.
are you well?
Yes, I'm well, thank you.
Thank you. Um, Tell us, where did you obtain your first degree?
University of Durban, Westville. In
Yes.
1990, I completed it.
19?
90.
Yeah, just bring the mic closer so that we can hear you well. And the second?
The second degree was much later. It was through the University of Natal, as it was called then, in
Yes.
Pietermaritzburg in the year 2005.
Yes. What did you do after your first degree?
I served articles of clerkship with two companies. It was over a period of a year.
Yes.
And then I joined the Department of Justice
And what were you doing there?
with articles of clerkship or
No,
justice.
in the Department of Justice.
Okay, I started off as a prosecutor,
For how long were you one?
4 years in total, 3 years in court and 1 year as a senior prosecutor.
Yes. And then?
Thereafter, in 1996, I was given a position of acting magistrate, and I remained in that position for 1.5 years.
Yes.
And I was then permanently appointed as a magistrate in October, on the 1st of October 1997,
Where?
in Camperdown, in KwaZulu-Natal,
So you were in that position for how many years?
as a district court magistrate for 10 years.
And then?
Then I was applied to the regional court bench. I was appointed as a regional court magistrate in 1996, 2006, January 2006.
And for how long have you been in that position?
Actually, I'm in my 14th year on the regional court bench.
So all in all, as a magistrate, both district and regional, you have served for how long?
24 years.
24 years.
Yes, Chief Justice.
And what do your cumulative acting stints in the High Court amount to?
It's 18 weeks.
18 weeks is how many months now?
It's 4.5 months.
4.5 months. Did you experience any challenge migrating from regional court magistrate and then acting as a high court judge, or was it a relatively smooth sail?
To be honest, it was relatively smooth. I think because I've been a regional magistrate for such a long time.
Yes.
But I obviously needed to be with the judges, and especially for appeals and reviews, and to learn from their wisdom. That
Yes.
was definitely needed.
And were civil matters a challenge or not quite?
I must be honest there again, it was not quite a challenge because we had been doing civil work in the regional court.
Yes.
Civil jurisdiction was implemented a few years ago.
Yes.
And I've had a few stints there as well, and even last year was in the civil court. So the matters that came to me in the High Court, the civil matters, were relatively the same as what I dealt with in the regional court. So I did do quite a lot of regional court civil matters. I think it's about 700 cases.
Yes. And what is the longest period you've kept the judgment reserved for, which sort of embarrassed you?
No, not at all, Chief Justice. Without trying to be boastful, I generally deliver judgment very quickly.
I think you must be boastful.
Well, it was all within a week.
Thank
I
you.
think the two judgments that took the longest were in the regional court because of the complexity, and I think that was like 2 weeks, but that was many years ago.
Yes. And just before I hand over to the JP colleagues, can we agree that we're not going to have food until we're finished with the interviews and the deliberations? Thank you. JP, over to you.
Thank you, Chief Justice. Good afternoon, Ms. Ramdeyal.
Good afternoon, Judge President.
You well?
Yes, thank you.
Good, thank you. Ms. Ramdeyal, first, just to clarify one thing, the other stints that you did in the High Court was when you came back to do your part at matters.
Yes, Judge President.
Your actual appointments were from 30 July 2018 to 12 August 2018.
That
The
was
appointments
last.
that the minister signed.
Yes.
Right. And the other one was from the 18th of April 2017 to the 30th of June 2017.
Yes, the first was the term, and then it was just 2 weeks, and then it was the 2 weeks
And then
to
the
complete.
others you just came back to do parties, and no other cases were allocated to you.
Yes, Judge President.
Ms. Ramdeyal, I had a look at your judgments. I just want to point out something to you and hear your comments. The first one, which is a judgment that was taken to the Supreme Court of Appeal,
Yes,
and the petition there failed.
yes.
But I'm more worried about the judgment writing style.
Yes.
That judgment, the first judgment, at page 45 of the bundle, the numbering is at the bottom.
Yes.
You see it?
Yes.
I see next to line number 10, you say, and even if there are inconsistencies and defects in the evidence, the court is still...
You are not audible.
Thank you, CJ. You then say, and even if there are inconsistencies and defects in his evidence, the court is still satisfied that the truth has been told. Now, that was when you were dealing with a state witness.
Yes, Mr. Junior.
Yes, and thereafter you analyze the evidence of the accused. Do you see that?
Yes.
So it is as if the conclusion has already been reached when you look at the accused evidence.
Yes.
And I see you follow the same pattern with the other matter as well at page 122.
Yes.
You also first reach a conclusion about the evidence, you analyze the evidence and everything else, and then you look at the accused version.
Yes.
It is as if you have already decided on the state's version.
Okay, that was not the intention. Sorry, I'll wait for you to finish.
No, it's fine. You may answer.
Are you sure?
Yes, oh, sure.
I was just, I think that was the style, yes, as you say, and it was never, nobody brought it to my attention that it's incorrect.
Yeah.
So I didn't really make a conclusion, so to speak. I just analyzed and I go on with each witness and then I draw a conclusion towards the end of the matter upon the totality of the evidence before me. It's been the style that I've used, but if it had been brought to my attention by any judge or anyone, then I would have known that's incorrect. I tend to like doing it that way, so I have an idea and to know exactly what each witness has been saying, what I'm accepting, what I'm not.
Yes, thank you. And then in the matter of Tsangarakis, yes, page 82, 83.
82.
Yes.
Yes.
There I note on page 89, your order refers to prayers 1 and 2 are dismissed and prayer 4 is granted. But nowhere in the judgment is it clear what those prayers are.
Well, I just went according to the papers. Is it not in the first paragraph?
No, unfortunately not.
Okay, I think it was just taken for granted that those were according to the papers. I see what you mean.
And likewise, the reader will not know what prayer 3 was.
Yes.
Because you mentioned prayer 1 and 2, but you said nothing about prayer 3.
Can't even recall this, what exactly. And I do understand, I concede that it's not in there. Let me just see if it's anywhere else. Yes, it was just taken for granted according to the papers that were before me and the heads of arguments according to the prayers that they brought before. So, and that was how it was dismissed in respect of prayers 1 and 2.
Thank you. And then just lastly, the judgment on the Rule 43.
Yes.
I assume that you dismissed the wife's claim in that matter.
Yes.
But then you made an amount that an order pertaining to an amount that the respondent had to pay for the child
Yes.
to the amount of 1,125 rands. But it is not clear in the judgment how you settled on that amount.
How I settled.
Yeah, how you decided on
Can I-
1,125.
What page is that? 100?
107.
Okay. Just want to pay maintenance. I think that was the amount that had been submitted that he could afford to pay, if I remember correctly.
But when you made the finding, it's not clear in your judgment based on what did you make that finding. That is my question.
In taking into account all of the expenses. That was, yes, that was the amount that he could afford, and that was the only amount that, according to all of the aspects that I considered and found that it was a suitable amount, because he was actually paying lots of other amounts already in respect of medical expenses. I could not grant that application exactly in the amount that the respondent or the applicant wanted, because it would have been exorbitant for him to have paid.
Thank you, CJ. I have no further questions. Thank you.
Thank you, JP. MEC?
Thank you very much, Chief Justice. Me Ramdeyal.
Yes, ma'am.
Okay. The Free State Province,
Yes.
that's where you are based,
Yes.
is currently sitting with more than 5,000 cases on foster care grants. And you have been called, all of us, to go account to Parliament. The challenge has been dragging for about 4 years now. We are supposed to finalize it within a month. By November. We should have done away with the backlog. What would you say, what was the role that you have played either to exacerbate or to reduce the challenge that we are sitting with, because these cases are dealt with in all magistrate courts?
Okay. Good day, ma'am. Unfortunately, that aspect is not before the regional courts. We do not deal with that at all. So we cannot, as a regional magistrate, have not played any role in that aspect because of the criminal and civil cases that are assigned to us. But I believe it may be being handled by the district court magistrates.
Okay. The report that I got is that even regional courts are also, we are all culprits, but I will leave it to that.
But
I'll take your word.
Yes, it's not assigned at all to us. If it is called upon us to assist, indeed, so we will gladly assist and see how we can help with that challenge.
Okay. I'm glad to hear that you are saying you are dealing with the cases that are before you very expediently. But I would just like to know what innovations are you bringing in your daily work to ensure that farming communities and rural communities are not adversely affected by postponement of cases in terms of transport, release from work, the strain on the victims themselves?
Yes.
What innovations?
Firstly, what I, and I think also my colleagues do, is that we try to assist the witnesses that come to court to prevent unnecessary wastage of time and funds and to take them away from their work situation. If necessary, and as you mentioned, from the rural areas, and if they cannot come to court, I know for a fact that the prosecution and prosecutors that work with us work in conjunction with the police, and the police officers have been very helpful in that regard to transport them. So we try our best to assist the witnesses that come to court, but unfortunately sometimes some matters take very long with witnesses, especially when there's a private attorney involved and the cross-examination is lengthy. Then we have to unfortunately postpone those matters and witnesses have to go home. But we are trying to prevent that situation.
Lastly, from my side, Mayor Ramdeyal, what advice will you give the country on making the protection orders to be effective? Because currently they are really not as effective as they should be in protecting the victims.
Protection orders as in domestic violence. Yes, ma'am. That is a challenging situation, and I would think that to make it effective, when someone is charged for breaching that order, he must be dealt with accordingly, and the sentencing that is imposed must be a sentence that's just, that's going to have a deterrent effect. Then when the people receive those orders, and they will understand the severity of it, and that it is indeed necessary to comply and not to breach those orders.
Thank you,
I
Chief
hope I
Justice.
answered your question, ma'am.
Thank you, MSc. Commissioner Msomi.
Thank you, Jay. Good afternoon, ma'am.
Good afternoon, Commissioner.
Ma'am, what is the role of a judicial officer or a judge in a developmental state? And how do you foresee yourself or see yourself fulfilling that role
Sorry, so in what state?
in a developmental state, ma'am?
Of the country? Well, or in judiciary, or in the country as a whole, if I may ask?
I think simplify it, sir. Some of these terms could be heavy.
No, it's fine, I can...
No, please simplify it for her, if you don't mind, Commissioner Msomi.
Perhaps let me try and ask the question differently, and I'm going to come back to the question I was asking. Are you a conservative or a liberal judge, and what do you understand by those terms?
In South Africa, and in application with our law and with the Constitution being the supreme law of this land, we cannot really say we're conservative as such. We have to be more liberal, but within the boundaries of the law.
Now, the cited cases that have demonstrated how our justice system has tried to be in line with the imperatives of a developmental state are those of Grootboom
Yes.
and the treatment action cases that dealt with the provisions of the ARV. And that is what I meant when I asked the question, as a way of an example. How do you then see yourself as a judge in a state like ours, where there is a need to protect the marginalized, the vulnerable, the poor, against those who are powerful and rich?
Okay, in terms of our Constitution, fortunately there's access to justice for all and equality for all before the law. So there is no need for the poor to be deprived of any justice in that regard. I think that's an important criteria. The Constitution has assisted in those aspects, and it has definitely been work in progress. We've moved forward. In the development stage, we must also assist, and since everyone's equal before the law, we cannot say we have to give preference or we cannot give preference, but we must assist the poor, the needy, the vulnerable with the best we can. And I think our judiciary, our system has already addressed those issues tremendously, especially with sexual offences courts and the vulnerable witnesses, protection of them, and as well as the victims in this matter.
Just last question. There are various bodies which have commented on your candidature, one of which is the Black Lawyers Association. And the Black Lawyers Association says, look, perhaps you are not ready. You have not had enough time as an acting judge. That's one concern. And then the GCP says your lack of experience in matters other than criminal matters might be a problem for you. What is your comment to those concerns? Thank you, CJ.
Commissioner, I come before the Judicial Service Commission today with almost 29 years of experience. I have potential, and I am competent. I'm very hardworking and I'm diligent. The fact that I've had only 18 weeks of experience in a civil, rather acting experience in the High Court is beyond my control. I have availed myself. I believe that I am diligent and that I can make a difference. And the regional court, the 14 years that I've spent in the regional court, has properly equipped me to deal with many matters. And I believe rather that I will be a competent judge and I will be able to handle the matters there. So if it is considered to be lack of experience, I don't think that should be much of concern, because I am someone that will prepare and ensure that I know what I must deal with before I take up that particular matter. Thank you.
Thank you, Commissioner Msomi. Commissioner Norman?
Thank you, Chief Justice. What's the time? Okay. Good afternoon, Mr. Ramdeyal.
Good afternoon, Commissioner.
Thank you. I just have two questions. They relate to the judgments that one of the judgments the Judge President has made reference to. Yes. But let me just start with that judgment. I must, just like the Judge President, I must say that I had difficulty understanding what exactly is it that you were dealing with in that judgment.
Is it the first one?
The first one of, let's start with the Bishop one. Let's start with that one at page 101, first of all.
Yes.
Thank you. If you turn to page 102, please.
Yes, I am.
Paragraph 7.
Yes.
I see there that you deal with the applicant's financial disclosure, which you find that is not really a true, that's what they were alleging, it's not a true reflection. But in the judgment itself, you don't deal at all with the applicant's finances and expenses, income and expenses. And then to tie in with what we asked then by the Judge President, then it becomes difficult to understand the basis upon which you arrived at the amount that you ultimately decided that the respondent had to pay. Do you agree that that is in fact the case?
Yes, it is so, ma'am. The Rule 43 is we were told that you don't really have to write a judgment. It's an interim order. But it was my first stint, and I just wanted to have something in place for each matter. And hence I wrote this matter. So I didn't go into too much details with the Rule 43.
Yes. No. It's because, as you know, in the Rule 43, you actually do the balancing act.
Yes.
Okay. Now, if you decide to write a judgment, you agree that you must write it properly.
Yes, it must. But
so once you've done that and you've decided to write the judgment and you've put in the respondent's income and expenses, you must do the same with the applicants. Do you accept that?
Yes, ma'am.
Yes, thank you. Now, if you may then just go to the one that the Judge President asked you about. I'll tell you the biggest difficulty I had there was the usage of the term applicant. You have two applicants there, and you hardly identify which one you're referring to.
Which one is that?
I'm so
again?
sorry, at page 82. Yes, page 82.
Okay, then apologize for that.
No. It's not so much about an apology. It's about just paying attention to those kind of details. I just without really, I hope you're not going to look at this as bad criticism.
No.
I'm just trying to just alert you to some of the very pertinent matters that you unfortunately didn't attend to, and as a result, I could not appreciate your judgments because of those. If you could please turn to page 85, paragraph 10.
Yes.
There, The applicant, however, disputes that the first respondent has a cash flow problem on the basis that he has 23 registered properties on his name and basically a wealthy man that can provide cash himself in lieu of the bank guarantee. But then when you look at the first respondent is actually Khato Project Management, Pty Ltd. And you have referred to that first respondent as a wealthy person, and you make reference to a human being, not a person, not a juristic person there. Do you appreciate that?
Yes, I do.
Thank you. So you agree that those errors may have, perhaps for a person who was really looking forward to your judgments, may have discouraged one appreciating what is it that you really wanted to convey.
Yes, ma'am.
Yes, thank you very much. Thank you, Chief Justice. Thank you.
Thank you so much, SC President Maya.
Thank you, Chief Justice. I also share one of the concerns raised by the Judge President Musi regarding the manner in which you deal with evidence in your judgments. In the one, it's in the case of State versus Makuvele, in your criminal trial judgments. And I picked up many more examples of what he was complaining about, than the ones that he actually mentioned, where you deal with this witnesses' evidence, and then you make a finding right there and there that the evidence is reliable. Then you move on and you deal with the next witnesses. Now, I want to find out from you, what is the approach that a court assessing evidence in a criminal trial is supposed to adopt? How does a judge evaluate evidence? What do you do?
To evaluate, good day, President Maya. To evaluate all of the evidence, to basically, I would think, just summarize everything and do it at the end. Didn't consider the totality of the evidence as discussed and weigh up the evidence that's before the court in the state's and the defense case. Look at the probabilities, improbabilities, strengths and weaknesses on both sides, and then decide whether the state has proved its case beyond reasonable doubt or whether the balance weighs heavily in favor of the state.
I do agree with you. You coined it perfectly, but that does not appear when one... I remain in doubt that you actually know what the test is when I go through the judgment. So maybe that's something you should just polish up on going forward. Thank you, Ms.
Thank you.
Ramdeyal.
I also appreciate that I've also went to the Sajay courses, both of them after this. So I think I learned more as well from the course.
Judgment writing is work in progress.
Yes, it was very good.
Thank you.
Thank you, President. Commissioner Masuku.
Thank you, Chief Justice. Good morning. Good morning, ma'am.
Good morning, Commissioner.
In a way, my question is been dealt with by Commissioner Norman, but I just wanted to add to in addition to what she asked you. One of the paragraphs in the case she referred to in page 8 on page 82. There you say you deal with the principle of specific performance.
Yes.
And you say that there was a fear that if specific performance is ordered, then and it was not complied with, could be enforced through a contempt contempt proceedings.
Yes.
And then in paragraph 19 you say an order of specific performance may operate unduly harsh on first respondent and may not produce the result required by the applicant.
Yes.
Now, what was the basis for reaching that conclusion that specific performance may operate?
There was
because it's not clear in the judgment that there were certain factors that you took into account to come to the conclusion that that specific performance may operate harshly against the first respondent.
There was a previous order that he could not comply with, appeared to have serious cash flow problems, and the applicant in the matter eventually, counsel for the applicant eventually did concede to that effect. Hence, there was also, think I refer to that in my judgment. I'm just trying to find it. Yes, it is somewhere in the judgment. I'm just trying to. That is with the reasoning behind it, and hence that is why I mentioned that.
But this question, I actually don't know what the answer is. So if you know the answer, or if any of the commissioners know the answer, I am happy to be educated on it. If a specific performance is ordered by a court in the context of a contract, and the person against whom specific performance is ordered by that court is unable to perform, what would be the implications of enforcing that specific performance through a contempt of court proceeding? Would that not be to use contempt proceedings to force specific performance in situations where somebody has breached a court order? I mean, I don't know what the answer is.
I think they can, but I just thought that would be futile in this case because they could have sought some other remedy in this matter. The circumstances and the papers before me did not warrant or allow a specific performance order to be granted. Hence, I dismissed that application.
Thanks a lot, Mr. Commissioner Mpofu will give me the answer on payment of a fee. So he is offered.
Thank you, my brother. Prof.
Thank you very much, Sujay. Good day, Mr. Ramdeyal.
Good day, ma'am.
Just a quick bite on your understanding of transformation of the judiciary with reference to case law that emanates from it. A reason being, how would you determine the effect of the order that you grant from your court?
How would I determine the effect of the order?
Yes, the deterrent effect, because you are more on criminal law as well.
Yes.
Then how would you determine the deterrent effect of the order that you may grant against a particular person?
As in a verdict or sentence or any order?
Yes, as a sentence.
Okay, I hope I understood your question properly. But anyway, the sentence, if I had to pass a sentence, the deterrent that it must have is to pass a message to society, to the offender himself, and to potential offenders to prevent such an offense from occurring. So that is the effect of it, and obviously taking into consideration all of the circumstances that you would deal with in the sentencing process. But the order that I would grant in passing a sentence where there's like a lengthy term of imprisonment, if it's a rape or a murder matter, must be effective. It must go out to the community. It must reach the people to know that this kind of crime is not going to be tolerated by the courts.
Then how would you quantify that in the light of the scourge of gender-based violence against women, notwithstanding the many cases and the decisions and the sentences that have been granted against those who have been sentenced for committing these serious crimes? How would you quantify that in terms of being a deterrent effect, as sending out this message that this is wrong, this is unacceptable?
Commissioner, I think we must apply the minimum sentence legislation like it comes to cases with rapes of women and murder. We have minimum sentences in place. It is so that if there's substantial and compelling circumstances, as a court of law, you're allowed to deviate and impose a lesser sentence. But I've seen very lenient sentences go through the system. And that is something that must be addressed. There must be parity of sentence on the regional court bench, on the high court bench. This, I believe, will have a deterrent effect. Then the message will be clear to the offender, to potential offenders, that the courts are not going to treat these crimes lightly, and that we will not tolerate crimes of violence and gender-based violence.
Honorable Singh.
Thank you very much, Chief Justice. Good afternoon, Ms. Ramdeyal.
Good afternoon, Commissioner.
The one question has been canvassed by Commissioner Msomi with regard to the comments from the law bodies, and in particular what the BLA had to say. But I think I'll just pick up from Commissioner Nklama about gender-based violence. Now, we know it's a scourge, it's a cancer in our society at the moment. The President has intervened, the Chief Justice has intervened, and many people society has intervened. And one of the things they're saying, there should be no bail for the accused.
Yes.
I'd like your response to that as a judicial officer. And secondly, I believe that it's not only the law that is going to deal with the issue of gender-based violence and femicide, etc., but it goes beyond the law. Have you encountered any cases where you've gone beyond application of the law in assisting victims, whether they be children or women, in dealing with this kind of issues? And can you give us that example? Thank you.
Yes, thank you, Commissioner. Prior to my appointment as the Regional Court Magistrate, when I was still in KwaZulu-Natal, I had already been assisting in domestic violence matters there. And that was also very prevalent, and not only at the courts, but in the community. When I moved over to the Regional Court in the Free State, I've been dealing, as you know, with the Sexual Offences Court continuously for 10 years, and we've had prevalent offences, and there's been, yes, what we can call a pandemic at that time already. I could not really get involved out of the community because Welkom's a very small center. We had to be very cautious with that because of my continuous role in the court itself. The question, yes, I think I gained the reputation of being this rape magistrate. So what happened is there was lots of attorneys that refused to let me deal with their matters. Accused persons would refuse to let me try their cases. So I had to be very careful how I dealt with it in order to ensure that the wrong perception was not going out. Be that as it may, yes, we have it's a pandemic again with gender-based violence that must be deterred. The whole issue of bail must be seriously considered. If it's a Schedule 5 or a Schedule 6 matter, it must be dealt with according to those provisions, and bail must not be readily granted. It must, obviously, if an accused person is entitled to bail, that's his right, then it has to be given to him. However, if there's previous convictions of that kind of offense, and I see that very often in the regional court, accused persons in serious violent crimes are appearing before me on warning. They've been released on warning, and we have a problem with getting them to court. And we've addressed this with the senior prosecutors, and they don't really have an explanation because they say the courts are granting them bail in the district courts, or releasing them on warning rather. So I think this is a serious problem because they're going to immediately think that these are matters that are not serious, and they don't come to court, especially when we have a rape matter with 4 or 5 people that's charged, or a murder matter. I've had, like the other day, about 7 accused persons charged, and you can never get them all at court. So the whole provision of the Bail Act really must be revisited, and it must be seriously considered because we in the regional court currently are having a problem with this.
Thank you, Chief Justice.
Thank you so much, Honorable Singh. You're excused, ma'am.
Thank you, Chief Justice. Thank you, Commissioners, for having me.
Good afternoon,